How many holders support Ripple? When will the SEC listen to reason? Will XRP cost $2? We will answer all these questions in today's video. If Ripple prevails in its legal fight with the U.S. Securities and Exchange Commission, SEC, the relisting of the XRP token on the main U.S. crypto exchange Coinbase will be one of the greatest headlines in the XRP ecosystem. In a recent interview, Coinbase's chief legal officer, CLO, Paul Grewal, has talked in depth about the matter and outlined how the XRP relisting process would work. Coinbase banned XRP trading in January 2021, soon after the SEC filed its complaint, and has since kept the coin suspended despite vociferous XRP community requests. Grewal stated his hope for a Ripple triumph in yesterday's discussion with Thinking Crypto presenter Tony Edward, but also highlighted that a relisting does not rely entirely on a trial court success. Grewal said that the U.S. crypto exchange assesses assets on a regular basis for listing, delisting, or halting. He also understands the XRP community's angst. I realize it has been irritating for many XRP holders that they have not been able to trade their assets on Coinbase while this SEC action has been ongoing, Grewal said, adding that the SEC has not prevented Coinbase from closely monitoring the state of the dispute. Grewal, like everyone else, is looking forward to the judgment and lauding Ripple's attorneys' efforts. I definitely paid attention to the fact that the defendants in this case have done a fantastic job of pushing the SEC and raising fundamental concerns about the SEC's overall argument. Coinbase has filed an amicus brief in favor of some of Ripple's arguments. According to Grewal, Ripple's CEO Stuart Alderety and the rest of the fintech business have done an amazing job, which is why he believes the court will rule in Ripple's favor. We'll show that the SEC ideas are flawed. I believe the briefing in this case has been outstanding, and we will all soon see what the trial judges think of the arguments. Nonetheless, the Coinbase CLO emphasized that, in his judgment, the Southern District Court of New York's ruling is merely the first stage in a prolonged process. Grewal feels that regardless matter who wins in court, both parties in the case will appeal. Grewal added that the timing for relisting following the trial court judgment relies on the reasons of the judgment, the judge's legal rationale, and Coinbase's opinion of whether or not the decision would be upheld by the appeals court. Therefore, a lot is going to rely on the particulars of that court rulings. I realize it won't be very pleasing for some, but as a publicly traded firm, we have a duty to tread cautiously in this area, and with regard to any token that's the subject of federal court action, Grewal said. Finally, the Coinbase CLO said that the exchange would begin the review process as soon as the judgment is published. So, like everyone else, I am curious to see how the court decides, and all I can say is that as soon as we obtain the verdict, we will begin our process to see if we need to reconsider our listing decision. Ripple Chief Legal Officer Stuart Alderety responded to Coinbase's SEC Wells notification. SEC. A Wells notice is a SEC letter stating that a corporation or person violated securities laws. It gives the receiver 6 months to refute these charges before the SEC decides to take action. Coinbase received this SEC letter yesterday. According to Coinbase's chief legal officer Paul Grewal's blog post, the warning gave Coinbase nothing to react to. The statement claims that an undefined part of the exchange's tradable assets, Coinbase Prime, and its self-custody wallet violate investor protection regulations. The crypto exchange was investigated last year. In a case against former Coinbase employee Ishan Wahi for insider trading, the regulator also alleged that 9 exchange assets were unregistered securities. Coinbase still trusts their asset listing procedure. Coinbase does not list securities, Grewal said in the blog yesterday. In recent weeks, the crypto exchange has also asserted that its staking program is not an unregistered securities offering. In February, Coinbase rival Kraken settled SEC allegations by permanently ending its U.S. staking operation and paying a $30 million fine. Coinbase notes that the SEC authorized its operation and permitted it to become a publicly listed corporation in April 2021, days before SEC Chair Gary Gensler took office. In the previous 9 months, the company met with SEC investigators 30 times to register part of its operation and settle inquiries. Although Coinbase paid millions in legal expenses to identify viable registration models for Bitcoin, the SEC stopped the process in January. Gruel speculated that Gensler's numerous remarks urging crypto businesses to register with the SEC would fail. As reported in recent months, the crypto exchange seems to have been preparing for a showdown with the regulator. The crypto exchange recently revised its risk statement to clarify that it may not remove a listed crypto asset even if the SEC labels it a security until the regulator wins in court. Ripple is still fighting the market regulator on whether XRP is an unregistered securities. The blockchain payment startup got an amicus brief from Coinbase in its battle against the whole fledgling industry. If the SEC takes action, Consensy's lawyer William Hughes expects a flood of amicus filings supporting Coinbase. Alderity's responses and history suggest Ripple might support Coinbase. Hughes believed that if the SEC enforces, the court fight would go years and beyond Gensler. The attorney predicts that factual issues will lead to appeals. In July, CryptoLaw founder attorney John E. Deaton called the SEC a compete complete and total disgrace. The regulator's actions angered and grieved the attorney. The attorney later tweeted that free marketeers would be disgusted by the SEC's actions. U.S. market growth is questionable. Once Terra and Fox collapsed, authorities, notably the SEC, seem to have initiated an industry-wide crackdown. Market players want unambiguous instructions. According to attorney John E. Deaton, the emails and papers relating to writing Bill Heineman's contentious 2018 address at the Yahoo Finance All Markets Summit, known as the Hyman Materials, will ultimately become public. If Judge Annalisa Torres cites the documents in her summary judgment decision in the United States Securities and Exchange Commission (SEC) case against Ripple, she is likely to declare them judicial documents, making them publicly accessible with some redactions, as explained by the CryptoLaw founder in a Twitter thread yesterday. Furthermore, he points out that the Heinemann records are also important in current litigation, noting the action against Dragon Chain over Dargon, an Ethereum blockchain token that the SEC also claims is an unregistered security. The lawyer emphasizes that access to the Heinemann papers is more crucial to the defense in this case than Ripple's fair notice argument, and he also reminds community members that courts have already granted SEC attorney client privilege arguments. Heinemann, the then director of the SEC's Division of Corporate Finance, said in the contentious speech that ETH is not a security since the blockchain is sufficiently decentralized. This is the same blockchain that Dargon is built on, as mentioned above. Deaton also said that Dr. Rosalind Layton, a policy scholar, had filed a petition in the Ripple case contesting the SEC's attempt to seal the records. Deaton also claims to have submitted a similar request under the Freedom of Information Act, which he plans to pursue. As a result, the SEC's enforcement action against Ripple over XRP 2 years later astonished many in the crypto world, prompting the Ripple defense to seek documents connected to the speech draft. Importantly, it begs the issue of why the government opted to target Ripple rather than Ethereum. Remember that the SEC first denied Ripple's request, claiming that the speech reflected Heineman's personal ideas and was therefore irrelevant to the case. When forced by the court to produce the materials, the agency changed its story, stating that Heineman wrote the speech with the assistance of the agency's attorneys, citing attorney client privilege. Nevertheless, the SEC ultimately gave up the records to Ripple in October, after 18 months and 6 court orders from 2 courts. Dr. Layton noted after submitting her application for access to the records that they would reveal whether there were any malicious reasons for the Ethereum free pass or if there is uncertainty among regulators, which would excuse perplexity among industry players. The SEC wants you to believe that it is concerned with disclosure, openness, and clarity. They are not to be believed. The shamefulness of their actions here will shock you when the truth comes out. Ripple Chief Executive Officer Brad Garlinghouse tweeted after the blockchain payment startup acknowledged receipt of the disputed papers.